State versus Jacob Daniel Jackson, cause 23-1012-609. Mr. Jackson is present in open court, seated at counsel table. He is unrestrained and unshackled, represented by Mr. Pertzer, his counsel. Deputy Prosecuting Attorney Wyrick is present. This is a first appearance.
Good morning, Your Honor.
Your Honor, good morning. Brett Pertzer on behalf of Mr. Jackson.
All right. Handle the arraignment?
Yes, sir.
Yes, Your Honor.
All right.
The state has filed an information. The defendant is charged in count 1, rape of a child in the third degree, count 2, child molestation in the third degree, count 3, sexual misconduct with a minor in the first degree, count 4, child molestation in the third degree, count 5, communication with a minor for immoral purposes, count 6, communication with a minor for immoral purposes, count 7, indecent exposure, count 8, communication with a minor for immoral purposes, and count 9, communication with a minor for immoral purposes, and count 10, communication with a minor for immoral purposes.
Thank you. Mr. Pertzer.
Your Honor, good morning. We acknowledge receipt of the information with the local counts with waive and more formal reading and are not guilty pleas to each count.
Thank you, sir. Sir, is your true name Jacob Daniel Jackson?
Yes, Your Honor.
Spelled just the way it sounds.
Yes, Your Honor.
All right. And Mr. Jackson, is it true your date of birth is May 14, 1987?
Yes, Your Honor.
All right. Mr. Jackson, one of my jobs as I sit here today is for me to read all the charging documents beforehand. I will assure you that I have read all the charges or charging documents, and after having read them, I find that there is probable cause to justify the filing of the cases against you. For that reason, I'll enter a plea of not guilty to each and every count for you. Now, I would normally at this point inquire about your ability to retain counsel, but you have already secured that, so I will not inquire further. I will, however, at this point take up the issue of bail or release conditions, and I'll hear first from the prosecutor, then I'll hear from Mr. Pertzer, and then I'll make an order.
Sure. First, regarding the conditions, the state is asking for the court to impose no contact with any minors, that's anyone under the age of 18 years old. The state is also requesting no contact orders with 6 individuals. Those proposed no contact orders have been handed forward to you. For Mr. Jackson to have law-abiding behavior, to not possess any firearms, and to surrender any firearms that he has, and to follow the court's other standard felony conditions. Regarding bail, Your Honor, the state believes that bail is appropriate under Criminal Rule 3.2. The state believes that the declaration of probable cause establishes a likelihood that if Mr. Jackson continues to remain released, there's a likely danger he will commit a violent crime. As the court is well aware, violent crime is not defined by the RCW. The court will make clear of that. I would report to the court that these themselves all fall within that definition. Specifically, given the length of time these allegations are alleged to have occurred, along with the numerous victims, the state believes that the court should make that finding. Under the relevant factors under Criminal Rule 3.2e, including subsection 3, the nature of the charges, the state asks the court to consider both the number of victims or alleged victims and the alleged length of time that these events occurred over, and impose bail in an amount of $75,000. Thank you.
Thank you. Mr.
Your Honor,
Pertzer.
thank you. And as the court will,
Just so you know,
Yes.
I'm going to be looking and signing or considering signing the no contact orders. I am listening to what you say,
Very good.
and I have reviewed your information you filed yesterday.
Thank you, Judge. Your Honor, the court's aware of the requirements of 3.2 before bail is to be imposed. There's a presumption of release on personal cognizance, unless the state can show that the person is likely to commit a violent offense, a flight risk, or likely to hinder the administration of the case. In respect to judgment, none of those factors have been established. Mr. Jackson and through me have been aware of the allegations in this case in September of last year. After I was contacted by Mr. Jackson, I contacted the state. I've been in regular contact with Bryce Nelson, who's the charging deputy in this matter. There was a DNA request that was obtained, but that was taken care of in my office through Mr. Nelson. Mr. Jackson, as the court is aware, is 35 years old, has no criminal history. He's been in the area for the past 13 years, is married, has 2 minor children, which are outlined in my materials. There was a letter from his wife asking that he be allowed to remain in the home during the pendency of this case. There's nothing's changed over the last 8 months except that now formal charges have been filed, and we've been aware of this for some time. CPS did their own independent investigation when the allegations first arose. There was no danger that they noted to the children. Mr. Jackson's father-in-law, Terry Robinson, is here as well. He and his wife are fully aware of the situation. They're supportive of Mr. Jackson, along with his wife. Pursuant to the court rule and the case law, we'd ask the court to release him on his personal cognizance, to allow him to stay in the family home with his family, to have contact with his minor children, but no objection to contact or having no contact with any other minors, specifically the individuals who are named in the no contact orders. I believe that follows the spirit of the rule and also the case law that's been developed in the recent past.
Thank you.
Your Honor, if I could- 1 second.
We're not gonna go back and forth, but I'll allow you to go.
I just want to say I agree with Mr. Kurtz's representations, just for the court's knowledge regarding the procedure of this case when he became aware of it, and also the state, under the case law, does object to Mr. Jackson having contact with his own minor children.
When the court sets bail, many people assume the court has something like a wheel of fortune that I spin and comes up with a number. And that's not the way bail is set. Bail is set according to what the Washington State Supreme Court has ordered under Criminal Rule 3.2. And it requires the court to consider 8 discrete factors and balance those factors. Among other things, it includes a person's history or likelihood to reappear for court, because that's what bail does. It ties a person economically to the area to give the court some assurance that they will appear back. And when I look at that, I look at a person's criminal history. To Mr. Jackson's credit, he has no criminal history at all, and that speaks well of him. But other factors the court must consider also have to be balanced, and that includes danger to the community or danger to victims in this regard. And I do have some concern. Obviously, from the turnout today, the community is taking this to heart, as well they should. These are serious allegations that impact all of our community. In fact, I routinely have murder cases here that don't have 1/100th of this kind of turnout. So, obviously, people have taken this to heart. What I'm going to do is strike a little bit of a middle point that I think does balance the safety of the community and assure that the community is taken care of. I'm going to require $25,000 bail and electronic home detention through friendship diversion. Means you will have an ankle bracelet, sir, and that you will be confined effectively to home, but you may leave for work, court hearings, attorney conferences, things that Mr. Pertzer might need you for job interviews, treatment, counseling, meetings with a bail bond company, and any medical appointments you have. Because I'm allowing you to return home, you will be able to return home. You're to have no contact with minors, and I'm taking that away from, I'm excluding rather, your own children. So your children are exempt from this. There will be specific no contact orders as to the individuals tendered, and I will require those no contact orders. In addition, you're not to possess any weapons or firearms, no marijuana, alcohol, or other controlled substances unless you have a prescription. So your travel is also restricted to Pierce, King, Thurston, and Kitsap counties. Do you understand those rules, sir? All right.
Your Honor, with respect to the bail, could we have 24 hours to post that?
No, I'm going to require him to be taken into custody today, please. That is not appropriate. I expect people to behave themselves in court. Whether you are happy or unhappy with this decision is a separate issue that you handle outside of court. That is not appropriate. All right, the court is signing the other orders. I'm signing the home detention order in this matter. Now, sir, you're also going to receive what's called a scheduling order. That scheduling order has 3 very important hearing dates coming up. Actually, it has arraignment date today, which doesn't need to be there, but it was already taken care of. So it has what's called an omnibus hearing and a jury trial date. Those dates are so critical. Please get that order on your refrigerator at home. Circle those dates in red. Program them into your cell phone. Mr. Pertzer's office, I know, will call you and prompt you to be present for those hearings. You do not want to miss a hearing. If you miss a hearing, a bench warrant is issued for your arrest, and your bail goes from what I set now to probably 4 times that amount, plus other conditions. So, really critical you're present at each and every hearing.
Log into the court docket. Maybe Brett. I just didn't
He wasn't in it.
docket. Proceeding on.
Oh, are you logged in? Why is there no one in proceedings at all?
You're logged in right now, Mr. Grant.
Well, Mr. Grant's not here, so.
I'm just Mr. Grant.
Do I let?
Yeah, there you go.
Sorry.
So you went on the right day, now you gotta do it.
Sorry. I wanted you to see what the.
Court has signed all of the no contact orders which were tendered by Mr. Wyrick's office. Very good. Yes, sir. Mr. Pritchard, do you want the memorandum back as a working copy, or do you want me to retain it?
You can retain it, Judge.
Thank you, sir. Now, when we're completed with this, and we will then ask media to break down, and they'll have an opportunity, once they're done to break down, we'll take a brief recess to let everyone exit the courtroom in an orderly fashion. Please go ahead and go down to the main lobby area if you wish to talk or converse or whatever it is, but do not clog up the hallway in the courtroom here. And I would ask you to remain civil and not say anything at all to Mr. Jackson or his family at this point. Just as it's inappropriate to cheer or applaud, it's inappropriate to make those kind of comments. I ask everyone to behave themselves and please act like a responsible citizen would. I know feelings run high with this, they should, but I do ask for people to moderate their